Welcome everyone to our updated session on collections during a pandemic. Who would have ever thought we would have used all four of those words together, but we do. Matt Fisher has very graciously offered to do this session, so we're very thankful for that. Our sponsor for today's session is Interprovincial Roofing. And Donna has just texted me to say you forgot the logos on the presentation. So when we get to the end, what I will do is I will put those on. Thanks, Donna. I'll put those I'll post those on and get the contact information. And Interprovincial is a roofing inspection and specification company, and they do an outstanding job. So if you have any questions relating to that, for sure. The session is recorded. These sessions all get posted. Remember that this is for educational purposes only. Just because you get your question answered by Matt doesn't mean you've been given legal advice or had legal counsel on a matter. There are so many particulars that we need to know before we can confidently answer a question that we're really looking at generic questions here, and you're always recommended to seek independent legal advice when you're looking at issues. And the only other thing is, if you could just put your questions into the Q&A, it's just easier to monitor one as opposed to the Q&A in the chat. So if you can just keep them into the Q&A, that would be great as we go along. And then if there's questions that are relevant to a specific slide, I'll monitor them and just bring it to Matt's attention right away so we can address it as we get to it. And without any other delays, Matt, they're all over to you.
Thanks, Tony. I feel privileged to be able to present on this. It is a topic I'm really passionate about, oddly passionate about, I suppose. There are technical and fairness aspects of collections, and I've had the privilege really of being able to argue this multiple times in court, most recently in front of the BC Court of Appeal, and we'll talk about that decision in a little bit. I do want to clarify that this is a shorter version than the full course that talks about collection of other charges. We're focusing today on those core charges that a strata corporation needs to be able to collect in order to operate, and those that are most strongly protected by the Strata Property Act by enabling a strata corporation to place a lien. So primarily strata fees, special levies, interest on strata fees and special levies where properly authorized, and protected legal expenses to collect those amounts. The longer seminar would include a detailed discussion on fines and insurance deductibles and other charges which can't be protected by a strata lien directly. So I am going to start with just some thoughts about how collections during a pandemic might feel a little bit different for strata councils, and some of the things that council needs to keep in mind when collecting during a time of particular hardship on individual owners. We will then proceed through some technical and legal aspects in as much detail as the time permits, and then we'll leave a little bit of time at the end for questions. So next slide, please. Thank you. Anytime there's a recession or a crisis that affects individual owners, it impacts the community, it impacts the strata council, and it makes it emotionally a little more difficult for strata councils to do their duty to collect the amounts owing to the strata corporation. You know, we are in an unprecedented time. Anyone who has their income affected or has their social circle affected knows that this is an unusual time, and it can make it difficult for the strata council to address collections in a hard fashion. And as an individual council member, you know, it is perfectly acceptable to be personally sympathetic, but you have to also keep in mind that you have a duty to the strata corporation to collect the amounts that are owing. And that can make it more challenging to serve on council, but you need to keep in mind the duties that do arise. And it's not just the fact that people's income might be affected. We know that because insurance costs are going up and because you want to maintain insurability, we're also having to spend more money on repair and maintenance. Strata fees are going up at the same time, or might be going up at the same time that people have more difficulty in paying those obligations. So the other thing to keep in mind is because people are having difficulty, it may make it more likely that owners might be going through either insolvency protection or bankruptcy, and those kinds of complications and factors can make it all the more important to take formal steps to protect the amount owing to the strata corporation and to do so promptly. So one of the things that we sometimes see the Strata Council trying to do is to provide formal arrangements to pay for owners who are in difficulty, where the council members may have personal sympathy for the owner. That can be, some relaxation of the normal due dates. But the thing to keep in mind there is that as soon as a Strata Council has that conversation with an owner or has that conversation among themselves, there are a number of things that follow from that. One is, you might be setting a precedent that other owners might want to abide by. You might be exceeding your authority. The Strata Council has no special authority to change the due date of a special levy, for example, and certainly not just for one owner. It is also, the charges for strata fees are due when they're due, and the Strata Council should be very reluctant and get legal advice before giving anyone time to pay. And that's particularly true because if the Strata Council gives owners a particular payment arrangement or time to pay, that can legally trigger obligations under the Strata Property Act, which prevent the Strata Council from withholding a Form F or prevent the Strata Corporation from registering a lien to protect the amount owing to the Strata Corporation. And that can be very problematic, and it can be contrary to the duties that the Strata Council has to the rest of the ownership and to the Strata Corporation to effectively collect the amounts that are payable to the Strata and to prevent other owners from being burdened with more than their fair share of the expenses. So why does the Strata Council have to take action? What are the duties that trigger? The Strata Corporation, first of all, needs strata fees and special levies to be able to fulfill its statutory obligations, to do what it is obligated to do, to repair and maintain the property, to maintain property insurance, to resolve unusual repair expenses. The special levies and the strata fees need to be paid and collected. And as soon as a Strata Corporation is underfunded, Strata Councils have to make compromises with respect to what's getting done. The owners have approved a budget, that drives what the strata fees are. And as soon as those funds are not being received, either the Strata Corporation is not making the contributions to the contingency reserve fund that the owners approved, or there is some other curtailment of services, repair and maintenance, or other objectives of the Strata Corporation. So the Strata Council has a duty to all of the owners and to the Strata Corporation itself to take reasonable steps to promptly collect the amounts that are owing to the Strata Corporation, and has a duty to the other owners to make sure that they're not unfairly burdened by one owner's failure to pay their fair share. Because you can't simply reapportion the contributions to expenses as a Strata Council. It has to be paid by unit entitlement, and the division of expenses has to be lawful. The other thing to keep in mind is that delay can prevent recovery or complicate it. The limitation period under the Limitation Act is normally 2 years to collect. There have been some unusual extensions during the public health emergency, but there is still a need to take prompt action because some of the steps take time to process. And if you leave it right until the limitation period is about to expire to commence collections activities, they can be prevented or complicated, and it can actually increase the expenses borne by the Strata Corporation or prevent collection. And the other thing to keep in mind is that having a reputation for being passive as a Strata Council can compound your difficulties. If the Strata Council has a reputation for being passive about collections or not taking prompt action, it can actually encourage owners who are dealing with multiple debts, such as credit card and other expenses, and the curtailment of income. It can encourage them to defer payment of strata fees unlawfully, and can actually spread among the strata owners if they perceive that other owners are getting away with it. So be aware of that as well. So how can the Strata Council be proactive? There are a number of different ways that you can. One is by deterring late payment by having a reputation and developing a reputation for being firm, fair, and consistent in your collections activities. Having a clear policy, having monthly meetings, we'll talk about some of those recommendations, enforcing the bylaws effectively with respect to prompt payment of strata fees and special levies. Creating that reputation for effective collections can help. The other thing that you can do as a strata council is encourage the owners to adopt bylaws which are up to date and facilitate assessment, payment, and collection of strata fees, making sure that assessment of fines and interest, as well as entitlement to vote and entitlement to serve on council, are properly worded bylaws. We've seen lots that are not properly worded, that do not match the enabling provisions of the Strata Property Act to have that kind of bylaw. Making sure that you have those bylaws properly drafted, properly approved, and properly registered can help. I also strongly recommend that strata councils look at their bylaws, and if you have a bylaw that says the strata council shall not take collections actions for 3 months or 6 months, revisit that bylaw, get some advice about that, consider repealing that with the assistance of the ownership, because there are circumstances certainly where having to wait 6 months or even 3 months where you know the owner is in insolvency protection or about to enter insolvency protection can seriously be problematic. So make sure that you don't curtail the strata corporation's ability to act promptly on unpaid special levies, particularly significant special levies or even strata fees. Have a clear, consistent collections practice when a payment deadline is missed, and make sure the strata council is meeting regularly to assess what is owed and how it's going to be collected. So that's where Choa's recommendations come in. Make sure that you as a council are meeting monthly, that the Strata Council is making the decisions necessary on review of the financial statements to determine who's in arrears, making sure that there are decisions being made about enforcing the bylaws for late payment, that the penalties and interest are being properly assessed and promptly assessed. That monthly review enables the council to look at what categories of arrears are accumulating. Is it special levies? Is it strata fees, fines? What's being left unpaid by owners? And form a coherent strategy for collecting those amounts efficiently and promptly. Making sure that liens are being filed in a timely way to protect the amount owing to the Strata Corporation. Determining whether further action is necessary, monitoring limitation periods, and making sure that you're tracking receivables in an itemized way that allow you to identify not just how much is owing, but what comprises that amount owing for each strata lot. So there are some pitfalls. We see a lot of different circumstances, but I've sort of summarized some of the more common ones. One is, if we get involved midway through a process, quite often we see issues. We review what's happened before, and quite often we will see issues where the Strata Corporation didn't send a notice to all of the owners on title to the strata lot, which is in arrears, or that the amounts that are being claimed, there are issues with the way the accounts have been kept for that strata lot. So make sure that the accounting records and owner contact information are consistently maintained and are correct and up to date. Make sure that owners have been properly informed of what they owe and how they're expected to provide payment before they get into arrears. Make sure that strata fee increases and assessments of special levies are properly communicated to the ownership, not just distributed in the minutes, but make sure that you have some sort of process to draw attention to what people owe if it's an unusual amount. And make sure that if you do use pre-authorized payments or post-dated checks, that you're notifying the owner separately of the need to provide a revised pre-authorization form or to replace post-dated checks to ensure that they're not falling into arrears. Quite often people who are not paying attention to minutes will miss these kinds of things, fall into arrears, and unnecessarily complicate the Strata Corporation's activities, where just a little bit of extra communication can prevent those kinds of issues. Ensure that the budgets and special levies are properly approved. There's nothing worse than going partway through the process or all the way through the process and then having an owner say, well, this meeting was never held properly. The special levy was not properly approved. It didn't include the necessary wording from Section 108 of the Strata Property Act, for example. So double check that before you take formal steps.
Matt,
Yeah.
we could probably have a 2-hour discussion on pre-authorization forms.
Yes.
But one of the frequencies of failure that we see is that the form itself, oftentimes it is a form, it's not a bank form, it's created by the strata corporation or the management company. And oftentimes it will authorize the collection of penalties, fines and penalties or insurance deductibles. And so, I hate to say it, but most people don't read them. They just sign them. But what I think strata corporations are forgetting is they only can authorize them if the strata corporation has gone through a proper enforcement process.
That's right. There are several levels of authorization that are required. The technical compliance with the Act that allows you to claim those amounts in the first place, and then whether you have the owner authorization to then debit their accounts for those properly approved amounts.
Yeah. We're actually seeing where the PAP is being applied because the claim is, well, they authorized it, they signed for the form, we can automatically just collect this, but they can't.
Yeah, no, and there are all kinds of issues that come up there where a little bit of advice early on can prevent problems later on.
Yeah.
Thank you. And that flows right into checking that payments are applied correctly. We used to see this much more commonly, but it's still happening routinely in some strata corporations, and where fines are accruing and strata fees are unpaid, and the strata corporation wants to file a lien for both, or in fact has filed a lien for both together. You cannot file a lien for fines. And there's case law that says you cannot apply payments preferentially to strata fee to fines so that you can keep the lienable charges of strata fees unpaid. If an owner is disputing fines and paying the strata fees, you can't just apply those to fines. Some strata corporations will have a legitimate policy of applying undifferentiated payments to the oldest charges first, but if it's being applied preferentially, there are serious issues there. And the case law suggests that there's serious cost consequences for strata corporations that have prejudiced the mortgagee's interest by doing so, or the owner's interest for that matter. Another thing that we see often mistaken is interest being assessed without an authorizing bylaw or an unlawful amount, or it's being compounded more often than annually. The Act is very specific about the maximum rate of interest and how it can be compounded. Check that the interest is authorized by a bylaw, that the bylaw matches what the Strata Property Act allows, and that it's not in excess of the statutory maximum of 10% per annum, and that it's not being compounded more often than annually. Another error that we see frequently is relying on a Form F certificate of payment alone. That is, when a strata lot is sold, they will generally request a Form F certifying that everything's been paid. And some strata councils will say, well, we don't need to register a lien because we've got a Form F process that we can rely on. And that is not a reliable process. There are circumstances in which the strata lot can be transmitted to a mortgage lender without a Form F. There are other circumstances where a Form F has not been obtained and the strata lot did change hands. So that is not something to rely on. And it does not protect charges as a secured charge in priority to other claimants. So it's not an effective way to protect the amount owing to the strata corporation with respect to strata fees and special levies which have been unpaid. There is another process that council frequently misses, which is making sure that not only are they making the decisions about how to proceed, but they're documenting those decisions at council meetings, in council meeting minutes. These days you can hold electronic meetings for council, even if you don't have an authorizing bylaw during the public health emergency. So there's no excuse for not documenting the steps that are being taken and the decisions that are being made. So the procedural basics, under the Strata Property Act, and this is in sections 112 through 118, the Act specifically provides a process where the strata corporation can register a lien against title to a strata lot as an extraordinary remedy to secure unpaid strata fees and special levies and certain other qualifying charges against title to a strata lot where their fair share has not been paid. It is a very effective measure. It is also an extraordinary remedy, as I said, and where there are extraordinary remedies, technical compliance with the requirements is mandatory to make sure that you validly place the lien. So, and there's very, very strong teeth in the Strata Property Act to allow enforcement of that. One of the most effective things that is there as an available remedy if the lien itself does not solve the problem is that any strata corporation can enforce a properly filed lien by applying to the BC Supreme Court for a court-ordered sale of the strata lot without the owner's consent and without the consent of the mortgage holder or other charge holders, and the lien amount, including legal expenses, would then be paid from the proceeds of sale. So an owner doesn't pay their strata fees, doesn't pay their special levy, the strata corporation properly registers a lien, and then the strata corporation can go to court to enforce that lien and can force the sale of the strata lot. It's almost never necessary to go to that extreme, because usually what happens is if you're communicating with the mortgage lender or with the owner after you've registered a lien and you've informed them that the legal expenses will accrue with the strata fees and special levy and be protected by the lien and ultimately result in the forced sale of the strata lot, usually it's possible to get the other side to see sense and pay the amount without having to go to court. So the process is set out in section 112 through 118. It includes the process for giving the owner notice of the intention to register a lien and proceed to court-ordered sale, the process for registering the lien, and the process for going through the courts in summary fashion, all in those sections. The sections can get complicated, particularly if there are unusual circumstances. It can become complicated, but here are the basics. First of all, it's absolutely mandatory before placing a lien that the section 112 notice go to the owners of the strata lot and to a mortgagee if they filed a Form C with the strata saying we want to receive notice of arrears. That section 112 notice has to be sent properly. It requires 20 days notice and specific wording. Has to set up the amount claimed and the 20 days to pay. And that other specific steps will follow. After the 20 days notice, the strata can register a lien against the strata lot in the land title office in a Form G. That requires the assistance of a lawyer or notary. It requires a certification by the strata council or strata manager as to the amount owing. Generally speaking, after the lien is registered, we will take an additional step of notifying the mortgage lender and the owner that the lien has been registered and trying to encourage them to pay voluntarily at that stage. Warning of what steps will follow. It's the second half of the section 112 test. And then once the lien is filed, there's a few court appearances that are required to get the strata lot sold. It takes some time, it requires some patience, but it's very, very effective. And as I said before, in most cases, it's not necessary to go that far. In most cases, once the lien is filed, it's usually possible to gain compliance with the payment obligations and bring everything up to date. So in terms of the notices, it is absolutely essential that it be correct, that it go to the right places, it go in the right method. So first, make sure that the amount claimed is correctly stated and calculated, that it was correctly approved, and includes the required wording under the Strata Property Act, warning that a lien may be filed or a court action may be taken to compel the sale of the strata lot. The notice must state and observe the 20-day notice period. It's worth spending a moment about why it's 20 days because we still see errors made here. The Act contains a bit of a trap here because it says you have to provide 14 days notice before you place a lien in section 112. But what is not stated in section 112 is that you also have to allow the first day and the last day don't count due to the Interpretation Act, and you have to allow for delivery under section 61 of the Strata Property Act, and deemed delivery to an owner by one of those authorized methods under section 61 adds another 4 days. So it should be treated as 20 days. Generally speaking, strata councils will send out a notice if they're being conservative about it on 1 day, and then 3 weeks later, they'll send out instructions to take further steps or have those ready to go. But making sure that you both state the 20-day deadline and observe that is really important. The notice has to go to all owners of the strata lot, not just the owner who you're most accustomed to hearing from. If some of them have requested notice outside of the strata lot at a different address, you have to send it that way. You can only send it by email if they've requested that you send notices by email to them. That's stated in Section 61 of the Act. You also have to send notice to a mortgagee if they've notified the strata corporation in the correct form that they want to be notified of any potential lien placement. So the Form G certificate of lien, once filed, it's a certification by council of the qualifying charges which have accrued. It has to be correct. If it's not corrected, if it's not correctly stated, if it's not correctly certified, or if the correct notice hasn't been sent, it's of questionable validity and you need to get advice about whether there's any way to fix it. Once properly filed in the Land Title Office, however, it does do quite a lot of heavy lifting for the strata corporation. It will secure the amount claimed. In an insolvency or bankruptcy, it turns the strata corporation into a secured creditor, which is handled differently and paid out in priority to other claimants. It secures the value of the strata lot and takes priority over the mortgage and most other charges which are going to be registered on title. It's very, very effective at securing those charges in most cases. It prevents transactions, sale of the strata lot normally, and even remortgaging can be inhibited by the placement of a strata lien. And it makes the next steps possible as well. It is absolutely essential to avoid the pitfalls that do commonly arise with respect to lien placement. Double check and triple check the amounts claimed and other errors in the lien document, in the certification and the registration. Do not include fines or other debts in a lien which cannot be included in a lien. It happens all the time. And in some cases, it will invalidate the lien and all of the claims that the strata corporation would otherwise have against the owner. In the best case scenario, it complicates collections extremely and makes it more expensive for the strata corporation and can jeopardize the ability to recover the legal expenses in the process. That is key. You don't have to actually register a new lien every month as strata fees remain unpaid. But if there are dramatic changes in the amounts owing, there's a mixed case law about when you have to register a further lien. And certainly if there is an old lien in place for 1 month's non-payment of strata fees and a $20,000 special levy contribution becomes payable by that same strata lot and goes unpaid, you should definitely get some advice about whether it would be sensible to register a further lien in that circumstance. And I would recommend doing so in most cases. So that is it's questionable because of the case law, but it's worth thinking about and getting some advice on. More importantly, do not assume that registering a lien will stop the running of time under the Limitation Act with respect to commencing a court action. The Limitation Act says that you must commence a court action within 2 years of the cause of action becoming known to the Strata Council. And registering a lien is not a court action. Registering a lien does not stop the clock. So the lien does quite a bit to protect the interests of the strata corporation. But if 2 years go by and the lien has not been the subject of further action, if the strata fee payment or initial due date is more than 2 years old, as a matter of fact, it can, subject to extensions of the Limitation Act due to a public health emergency, it can jeopardize the strata corporation's ability to collect altogether, including any self-help remedies that might be available. So do not assume that registering a lien is all you need to do. It is not. It is also important, and we sometimes see this missed, if you receive full payment from the owner, you have a very limited time to discharge the lien, and you should do so promptly. Placing a lien against title without authorization and without complying with the Strata Property Act, or leaving a lien on title when you are obligated to remove it, actually can constitute an actionable trespass against title.
We should probably answer a bunch of lien questions while we're on this slide, because a whole crop of them have just popped up.
I am happy to.
So I think the big question that everybody struggles with is, how much money should somebody owe before we file a lien? You know, if somebody's missed 1 or 2 months of strata fees, it's fine if you can get communication, acknowledgement, and get them to realize they've got to pay them. But at what point here should you really be filing a lien?
That's a great question. I think it depends a lot on what policies the Strata Corporation has adopted in the past. I think a Strata Corporation that has for years not registered a lien after 3 months of strata fees and without notice does it against a particular owner who's got issues with the council, is going to face criticism for handling it differently. So there are lots of complicating factors that come into this. My view is that there is, by the time the council meets to address the issue, you're probably already a month in arrears, if not 2 months. And if the strata fees are significant, the owner has a history of not providing payment, or there's concern about that owner going into insolvency protection, there's very little reason to wait. Some lawyers and agencies say, you know, after 3 months of strata fees, you should be placing a lien. That doesn't mean that under some circumstances you shouldn't be placing it earlier. And some strata corporations have a policy of zero tolerance. That is to say, they will send a lien notice at the first council meeting following the non-payment of strata fees, and they'll register a lien promptly after that 20 days. You're still looking at close to 2 months by the time that process concludes and you've got a lien registered. And at that point, the owner doesn't really have a lot of excuse for not having made payment. It is, I think, something where the council has to balance risks, however. If there's a relatively small amount owing, I'm not going to say that the strata corporation waiting 2 or 3 months before registering a lien for strata fees alone is in error or is breaching the trust of the rest of the ownership. I wouldn't wait any longer than 3 months, but I don't think it's entirely a one-size-fits-all kind of solution. It does depend how often the council meets. It is a reason to meet more frequently than every 3 months, in my view.
I was going to say, and you know, even if the council doesn't meet, the treasurer should at least have a monthly report so that if there is a necessity of an arrears that comes up that needs a council meeting, one can be called.
Yes.
You don't have to meet every month, but you have to be aware of what's taking place with respect to your scheduling. We find oftentimes also that strata corporations, for some reason, want to have a special levy paid within a week of the special general meeting, even though the project isn't starting for 6 months.
Yes.
And that does two things. We find the first thing it creates opposition with owners who tend to vote against it. But the other thing is then it places them into a longer period of a collection cycle that has to be closely monitored and managed. And if your money is not needed for 6 months, why are you asking for it the next day virtually, right? Like why not give people 30 days or 60 days so that they have a little bit of time to organize their finances, especially when it's a substantial special levy.
There are also circumstances where there's a change in management happening, the pre-authorized payment forms are changing, and you know there's a reason why 30 owners have missed their payment, and it's not necessarily entirely their fault, or maybe they're not following events as closely as they should. Being aware of what's going on in the strata corporation should inform these decisions. Also, if there's a significant special levy, there's no that's due, and it's needed. There's no way I can recommend a strata corporation wait 3 months to start that process to register a lien. So it really depends on the circumstance.
You covered this, and I think it's just worth reiterating that just the whole point that a lien does not replace the time period on the Limitation Act.
Correct.
That's just a big misunderstanding in the industry. It just gets parked and people forget about it, and 3 years down the road somebody comes along to try and deal with it.
That's right. Yeah, the lien itself should be placed promptly, and it buys you some time as a strata corporation. But the Limitation Act says not just that you can't collect amounts through court process, it says you also can't collect through collections agencies or any other efforts. The money owing simply evaporates if the limitation period does elapse. Now, there are ways to extend the limitation period, so you shouldn't just give up on debts that have apparently expired. Get some legal advice first, because certain types of acknowledgements by owners will extend that time. There are other circumstances that might arguably extend the time. But what I think the important key here is do not let 18 months from the oldest charge elapse without having a plan to get the either CRT proceeding or BC Supreme Court proceeding started to protect the strata corporation from the lapse of the limitation period.
Which pops up to a really good question of a strata with a council member that owes an insurance deductible. We're assuming they were responsible for the claim that should be charged back to that owner 5 years ago. Is it still chargeable or recoverable? That gets very complicated.
It does get complicated, and there's no substitute for actually asking a lawyer that. A summary consultation on that very topic would be warranted, I think. Either you need to be sure that you can take action and should take action immediately, perhaps because there's been an acknowledgement of that council member that they do owe the money in a way that extends time under the Limitation Act, which has to be a very specific type of acknowledgement. Or the Strata Corporation has to stop telling them that they owe that money if they no longer do. Either way, you need to know.
The other thing would be really helpful on liens. I think it'd be valuable, I think, for the public to now know that the filing and discharging a lien is an online certified service through land titles, which is the reason why you need to use an office, because not all notaries have a certified service for this purpose. Most of them do, but not all of them. That you need to use a certified service to file liens and to remove them, because basically you are, as the lawyer, you're attesting to the veracity of the claim that the lien needs to be filed, the amount, or canceled.
Right, and in fact, I have to know that I have the signed original in front of me because that's the certification that I'm making to the land title office. And quite often strata councils will send me scanned versions, which I can't accept, and it can postpone. And we clarify all of this in our original documentation, but it's a lot for council to keep track of. So you really need to read through the instructions you're getting when you're involving a lawyer or a notary and make sure that they are comfortable with this process, that they've done it a significant amount.
Okay, I'll jump out of questions now and let you keep going for a bit.
Thank you. So you can collect certain types of amounts owing from an owner through the Civil Resolution Tribunal. There are reasons not to do so for unpaid strata fees and special levies. Lots of the reasons are complicated, and we don't need to get into them. The main reason is, we'll talk about how the legal expenses are recoverable in a few minutes, but there are remedies that are only available in the BC Supreme Court, and that includes the most effective remedies. The BC Supreme Court has the jurisdiction to compel the sale of a strata lot to satisfy the unpaid strata fees and special levies, interest, and legal fees that have accumulated with respect to those unpaid amounts. And that remedy and the fact that you can recover the legal expenses for pursuing that remedy is the strongest incentive for the mortgagees to pay the amount owing. It's the strongest incentive for the estate of a deceased owner or for the owner themselves to pay the amount owing. Because if they look at the amount that they owe and they're thinking that legal expenses are going to add to that, and that the strata lot's going to be sold and they're not going to have control over the marketing or sale of that strata lot, it is a very strong incentive to come to the table and cooperate. And that is why most of these cases never have to go to court, or if they have to go to court, it's usually only the first couple of steps you need to go through. There are circumstances where it does need to be litigated, but if you go to the Civil Resolution Tribunal, the CRT rules prevent normally the recovery of legal expenses there. The CRT has much more limited jurisdiction, and you have to make sure that you're within their jurisdiction for the claims that you're advancing. The CRT is a great place to deal with fines, insurance deductibles, things of that sort, but for strata fees and special levies, if those are a significant portion of the amount claimed, or really any portion, BC Supreme Court is the correct venue. So that is partly because more effective remedies are there, and therefore more effective pressures can be brought to bear on owners and mortgagees to pay, but also because the legal expenses incurred there, as long as reasonable steps are taken and reasonable amounts are charged for those steps, those legal expenses are fully recoverable.
So you've planted the seed for something that's kind of quirky in the legislation, and I don't believe it has ever been tested through the CRT or through the courts. But if there, and now that we have all these extremely high insurance deductibles, if there is an insurance deductible that's a common expense, the Strata Council can automatically levy it without the need of a 3/4 vote under Section 158.
Correct.
Because it's a levy, that makes it a lienable action.
Correct.
Whereas if an owner is responsible for a claim, that claim for that deductible is not lienable.
Quite right.
You know, and that
So
it's bizarre that the legislation has two standards, really.
it is bizarre. There are lots of things like that where there are some unusual aspects that we might see fixed in 2040. My view on this, I take the practical view, and so far the courts have as well. When I'm going to BC Supreme Court because someone has not paid strata fees or special levies, and there are other amounts that are properly claimable, we will usually include a request for judgment on fines and other amounts that are not subject to the lien. And we won't get the same priority status. The mortgage will be paid out in after the strata gets its strata fees and special levies and legal expenses and interest. Then the mortgage will get paid out, and then any fines will be paid. But we can often get it done in the same process fairly efficiently, and the courts take a pragmatic view of that generally.
So here's the quirky discussion, and this came up with a strata corporation in the Fraser Valley last week. The strata council realized that their deductible is $150,000. The owner of the unit, who was doing their own home repairs that caused the leak and the flood, it happened back in September. They have no credit or asset left because the unit is fully mortgaged. So rather than go after the owner, because the owner was responsible, the strata council just automatically levied all of the owners, because then everybody has to pay, and it's a lienable collectible amount. The legislation really sets up some complicated situations for the public.
Oh, it does. And in many instances, the Beitig decision, which we'll talk about, says that other owners should not be burdened with certain types of events which come about because one owner dropped the ball. And that's underscored as a principle that, that the Strata Property Act sets out. And there's all kinds of clever arguments that can be made with respect to that issue. It becomes very complicated. So that leads us into the good news. I had the privilege to be involved in the Milligan decision, which we lost on the issue of legal expenses, but we got to revisit the issue in Beitig, made the argument in the BC Supreme Court, first before the registrar, then before the judge, lost both times, but I was very convinced as to how I felt Section 118 of the Strata Property Act was supposed to operate. And so we took it to the Court of Appeal, and the Court of Appeal, I think, correctly, and certainly set the law for British Columbia, set out what is supposed to happen with the legal expenses for non-payment of strata fees and special levy. So what the court determined was that the principle of the Strata Property Act is that reasonable legal expenses associated with registering and enforcing a strata lien for non-payment of strata fees, special levies, and other qualifying charges are payable 100% from the owner who didn't pay their strata fees or special levy in priority to the mortgage as part of the strata lien. And it's the actual legal expenses that are payable, as long as the steps were reasonably required to place and enforce the lien and reasonable amounts were charged for those steps. Critically important case for strata corporations who are looking at, particularly if you have multiple owners in arrears and you're worried about the legal expenses, that security that as long as the process has been properly followed and reasonable steps are taken, the actual legal expenses incurred by the strata corporation are payable by the owner who didn't pay. And the reason for that, the guiding principles identified by the court, were that it is the way that Section 118 was worded is similar to the way Section 133 of the Strata Property Act is worded. So 118 talks about the legal expenses associated with placing and enforcing a lien. 133 talks about the cost of remedying a bylaw contravention where an owner has contravened a bylaw. And the Court of Appeal specifically noted that the justification for both is that the expenses associated with making up for the default by that owner should not be burdened on the other owners who complied with the bylaws or paid their strata fees and special levies when due. Those legal expenses and other filing expenses should be borne only by the owner who didn't do what they were supposed to do. And the case was before a 3-judge panel of the Court of Appeal. All 3 judges concurred in the result. The written decision is about 30 pages long, and they specifically noted these are the principles. In fact, what the what they said is sections 116 to 118 of the Strata Property Act are remedial. They shift the burden of costs associated with collecting strata arrears to the delinquent owners who have failed to meet their obligations. And they said that that interpretation needs to be given a large, liberal, expansive interpretation to make sure that other owners are not burdened with those expenses, which would not have been required except for the owner not paying. It is a really useful decision for strata corporations. It doesn't mean that if you do the steps incorrectly, you're going to recover your legal expenses, or if the special levy was not properly approved, that's going to be a problem. But as long as all the proverbial ducks are in a proverbial row, it does mean there are very good remedies that are not going to upset the other owners who paid their share.
Whoops.
So there is some case law that came after BATIG. Oh, sorry.
Yeah.
Thank you. So the intention is to help ensure that owners who do pay are not having to subsidize the cost of owners who have failed or refused to pay. By the way, we sometimes see owners who refuse to pay strata fees in protest to the way that the Strata Council is operating, or in protest to something that's happening, or they refuse to pay a special levy because they didn't like the resolution or the project. The courts have said you can't withhold payments in protest. There are provisions in the Act that allow someone to make a payment and in protest and in trust to the Strata Corporation and promptly litigate whether a resolution was fairly done. But you can't withhold payment as an owner. But this is an interesting provision of the case from BATIG. Broadly stated, the Court of Appeal noted, in my view, the same legislative intent underlies both Section 133 and 118 of the Strata Property Act, that strata owners who comply with the bylaws and rules should not have to shoulder the financial burden of remedying infractions committed by non-compliant owners. Keep that in mind for bylaw enforcement as well. Thanks, Tony. So there have been subsequent cases, one where a master was overturned because they tried to readjust to a pre-BATIG standard of assessment of costs, and they were corrected on that by on an appeal. But there was a case where the BC Supreme Court said that the initial letter, the Section 112 letter that predates the registration of the lien, that notifies the owner of the arrears and threatens that a lien will be placed if they don't pay within 20 days, that cost, if it's handled by a lawyer, isn't recoverable. And I disagree with that view. I don't think that complies with what the Court of Appeals said in terms of how Section 118 should be interpreted broadly and liberally. And I particularly don't agree because Section 112 of the Act requires that notice as one of the steps required to register a lien. So I think that is an expense that's associated with registering a lien, but I'm not a BC Supreme Court judge, and a BC Supreme Court judge has said that, and it wasn't corrected on appeal. So there is some uncertainty, I think, as to how that will be handled going forward. But there is an ability, I think, to have a strata corporation enact a bylaw that allows, because payment of strata fees and payment of special levies when due can also be, if it's not done, can also be a breach of the bylaws. And so treating that as a bylaw enforcement process and treating the Section 112 notice as a necessary step to remediate the infraction of the bylaws can also provide a separate parallel justification for recovering that from the owner. That would not be in priority to the mortgage, but it's still there. There are some very common pitfalls when strata corporations try to collect without legal assistance. Errors in any stage in the process can actually make it more complicated, can prevent some of the recovery of the legal expenses, can prevent recovery of all the legal expenses, or can even prevent the recovery of the strata fees and special levies which are overdue. So get legal advice early in the process. If there are extra step counsel has decided to take, if the Strata Council is trying to correct their accounting practices at the same time that they're trying to collect, there are going to be some legal expenses that may not be recoverable, or the legal expenses recovery may be jeopardized in that way. But please do ask, if you have a lawyer assist you with this process, please ask to what extent they're going to review the notice and the other steps that went before their involvement. My view, I prefer to know before a court action is commenced whether there are any things that we need to correct, rather than waiting until we find out in the response of the owner that they're taking the position that the special levy wasn't properly approved. So make sure that you have that discussion with your lawyer as to what extent they're going to be reviewing what's happened before their involvement. So get advice early, especially if there are complications. So if the council is withholding a Form F, preventing a sale, where they're claiming an amount against the owner and there hasn't been any lawyer review of whether that amount is properly claimable, for example, an insurance deductible or fines. If a sale is being prevented and there might be a lawsuit against the strata corporation if the sale collapses, get legal advice early. Get legal advice before you make arrangements to pay with the owner or provide them to time to pay, or before you forgive any debt by virtue of the Limitation Act or any other reason. Make sure you get some summary legal advice before you make those kinds of determinations. If the owner is in arrears and is in a process of insolvency protection, bankruptcy, divorce, tax sale, municipal tax sale, or federal or provincial tax obligations, if there's litigation or charges against the strata lot, if the bank foreclosure is going on, or if the owner is deceased and the estate either has taken conduct of the property or there hasn't yet been probate, get legal advice about those kinds of complications. They can make a real difference in terms of what is logical to do and what is prudent to do. If there are charges on title that might take priority to the Strata Property Act lien, get advice on that. If there are amounts which may have expired, before you forgive those amounts or take them off the books, get some summary advice. And I repeated there, council agreeing to payment arrangements. That was inadvertent, but it is worth emphasizing. Thanks, Tom. So those are the prepared slides. I do want to thank you for your attention. How many people did we have attending by the end of the session there, Tony?
I think we were at 97 at one point.
So that's fantastic attendance. I think this is something that is really important for strata councils to get right, because part of your service as a strata council member is making sure that you're managing the accounts receivable of the strata corporation with the assistance of your strata manager if you have one, and doing so effectively. So I thank you for your interest. I'm happy to take questions at this point on the topics we've talked about.
So maybe we'll just talk a little bit, Matt, about, because there's a few questions in here that kind of touch on it. We'll just talk a little bit about strata corporations pursuing recovery of costs for fines and penalties. Mm-hmm. So, I think the, because we do have strata corporations who will just fine someone months and months and months on end, and not realizing that the fine was intended as a deterrent or behavior correction, not intended as a penalty or a method of raising money. And so, maybe a little bit on, at what point, first the, how do we collect fines? But then the next part is, at what point do we really go into that more serious collection process, which now is generally the CRT?
That's right. It would normally be the CRT, and I'm happy to chat about that. In the longer collections process, I spent quite a bit of time on that, because I do think that too many strata corporations treat it as a revenue source, fining, or some strata corporations don't bother fining because they see it as a hassle. Some strata corporations only fine and never take any further steps, and none of those are quite correct. It is a tool in the toolbox. Fining is a tool in the toolbox that has to be used where it's appropriate, and it has to be used appropriately. The process for issuing fines, because it is, again, I can't fine my neighbor for painting my fence. I'm not in a strata at home. It is an extraordinary remedy available to strata corporations. The process under Section 135 has to be perfect in order to correctly assess fines. There's lots of assistance out there as to how to do that correctly. But I was involved in the Drummond case, where the court chastised the strata corporation for assessing fines for years without taking further steps to enforce the bylaws. It is at some point necessary for the council to assess, well, clearly the fines aren't getting this owner to comply. What do we need to do? Do we need to go to the CRT? And usually that would be a relatively straightforward application of the CRT to have an order that they stop contravening the bylaw and an order that they pay the fines that have been assessed. And at 3 or 6 months after the conduct started, you're going to want to think about what those steps look like. The CRT is fairly effective for that kind of thing, as long as it's a fairly straightforward case, and it's a remedy that basically the Strata Council has to consider how they're going to gain compliance with the bylaws, and if fines are not being effective, then they need to look at what other steps they can take.
I was going to say a good example of that is going to be bylaws for short-term accommodations like Airbnb, which permit fining of up to $1,000 a day. So if you do have an individual who is and you have a valid bylaw and you have an individual who is continuously violating this bylaw, the value of your fines and your collections can mount up rapidly and can be quite significant within a month or two.
But absolutely they can. And at the point at which you have $300,000 in fines and you've done nothing further, I think the Strata Council should expect that the court might grant relief against an unreasonable penalty in that kind of situation, particularly if the owner raises valid concerns about whether the bylaw is legally drafted, was properly approved, was properly registered. If there were errors anywhere along the way, the Strata Council is going to want to know before a year has gone by, and a month may be where you start looking at, okay, what do we do?
The other thing here is that there is this comment here that a CRT route means an insurance claim. No, it doesn't. A CRT action can be that of a decision and action of Strata Council, and with some legal advice, even a small amount of legal advice on how to proceed with it, it can be very beneficial, can be economic, and very successful.
Absolutely can. The other thing that we often see are strata corporations that try to they're taking expenses that could be part of the strata fees and breaking them off as user fees for utilities and that sort of thing. Making sure that council is aware that as soon as you break it out of the strata fees legally, you're also making it more difficult to collect those amounts. It may allow you to divide those expenses more fairly or in a way that's perceived to be more fair, but it can prevent the placement of a lien if those charges are the charges that are disputed.
We're right at 4 o'clock, and I think we've got everything done. So thanks so much, Matt. We will get a copy of the slides sent to everybody, and we have some other handouts in the package that will include along, like a draft demand notice and an inventory of how to kind of segregate your expenses and collectibles every month, those types of things. Thanks again to Interprovincial Roofing for sponsoring the event. My apologies for not sticking it into the slides, but we changed the slides at the last minute and did a few updates. So that was easy to do. So we'll just get a reminder to everybody on that front. And thanks again for everyone for participating. It was really great for all of you to join us along. And we'll see you at the sessions in January, February, and next year. And hopefully this time next year, we're back to real seminars with real people in real spaces. So.
Human contact. Thank you, everyone. Thanks, Tony.
Thanks, Matt.